Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing.
What happens when telling the truth inside the Justice Department becomes a fireable offense? That is the real question hanging over this exchange, and it is why this moment should worry anyone who believes courts are supposed to be places where facts matter more than power.
Yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, "I didn't sign up to lie." In response to his termination, you made a statement on Fox News a little while ago saying, "At my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences." So, General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Emil Bovee, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always. And that's what I mean by zealous advocacy. He also accused Emil Bovee of things that Todd Blanche, who is one of the best human beings I also know, my Deputy Attorney General, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Emil Bovee and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing. We've also heard from others in other departments who are responsible for implementing the laws of the United States that they feel uncomfortable about having been asked to do things that they thought were unethical.
This is not about partisan sparring or legal jargon. It is about whether government lawyers are being pressured to cross ethical lines and punished when they refuse. If you want serious breakdowns like this, subscribe. At the center of this controversy is a longtime DOJ attorney who claims he was asked to back an argument he believed had no factual or legal foundation. Instead of quietly going along, he refused. According to his account, that refusal ended his career. That allegation is explosive because the justice system only works if government lawyers are allowed and encouraged to tell their superiors when a case does not hold up. If refusal becomes disloyalty, the system stops being about justice and starts being about obedience. If that distinction matters to you, subscribe. What makes the Attorney General's response so troubling is not simply that she declined to address the court issue, but how she reframed it. Rather than explaining why the disputed legal position was sound, she focused on timing, personal loyalty, and defending specific individuals. That kind of response avoids the ethical question entirely. The public is left without clarity on whether truth to the court is still the standard or whether internal loyalty now outweighs professional duty. If you want accountability-centered analysis, subscribe. The phrase zealous advocacy becomes dangerous when it is stripped of its ethical limits. Zeal does not override honesty. In fact, the law demands the opposite. Lawyers are bound to the court before they are bound to politics. When leadership emphasizes aggression without reaffirming truth, it sends a signal down the chain that resistance is risky and silence is safer. That is how ethical cultures erode quietly, one case at a time. If you want these warning signs explained plainly, subscribe. This hearing also exposes a broader climate inside federal agencies where career professionals increasingly report discomfort with directives they believe cross legal or ethical lines. That is not a coincidence. When leadership treats dissent as sabotage, whistleblowers stop speaking up until something breaks publicly. Oversight hearings like this exist precisely to surface those tensions before damage becomes irreversible. If you want to understand how institutions actually fail, subscribe.